Welcome back. Welcome back. I'm not going to go through another formal introduction, but if you can bear with me for one more sports analogy. No? How many, this is another generational thing. How many of you here have ever heard of Ted Williams? Oh, I'm so encouraged. Okay, what did Ted Williams do in his last at bat? He hit a home run. Is that a lesson for Comptroller Curry as he enters into the last lap of his term? As I think so. I'd like to give him a warm Alpi welcome and wish him the best in the rest of his term and thereafter.
All right. First off, before I take questions, I want to thank Lendit for holding this conference. It's really important from a public policy standpoint that regulators engage with industry, particularly when you're talking about the transformative effect that innovation will have on our financial services industry. So thank you. I want to thank again the sponsors from Lendit. This is an amazing conference, and thank you for having me speak at it today.
First of all, Comptroller, thank you very much for your remarks. They were very insightful and much appreciated from those of us who are in the banking industry and at the intersection of online lending. I am curious to know whether, in your view, the special purpose fintech charter that you've discussed would be subject to the Federal Reserve oversight as a bank holding company. So, for example, if a company in the fintech space formed a special purpose charter, would that company then become a bank holding company?
Right. That's one of the legal issues that we're having ongoing discussion with the Federal Reserve System over. But the important thing to remember is that there are definitional terms defining banks that change. So you really have to have it in the context of a particular entity and the type of transaction you're talking about. But again, that's one of the reasons why in terms of our efforts on financial innovation is to make sure that we have active and ongoing discussions with other regulators. And domestically, that includes the Federal Reserve on the payment side in terms of whether or not the bank holding company statute would be triggered or not. It's also part of our very long-standing interactions with the CFPB. I think it's very important that in terms of their Project Catalyst and what we're doing in our Office of Innovation, that there be the highest level of communication and coordination. And again, this is a global issue, so we do have ongoing discussions with foreign regulatory agencies, including, for example, the PRA in the UK.
Thank you.
Thank you, Comptroller Curry. I also appreciate everything you've done here with respect to this charter. The question I had was actually partly the question that was just asked was, I followed this very closely, but I haven't really understood exactly what the interplay is among the regulators with respect to this. And I know you touched on it briefly in your remarks just now, where the CSBS and the states fit into this, because they seem to be a little bit less excited about the prospects. So I'm just curious what your response is to that.
One of the things that I like to point out to people is no one at the OCC is saying that everyone in the fintech space has to be a national bank or operate under a special purpose national bank. And I think in my remarks today, I emphasized the fact that we think that being a national bank, whether it's special purpose or not, is really an extremely high standard. So fintech firms are free to continue to operate on a state-by-state licensing basis. There are some states that have chartered fintech firms through limited purpose trust companies specifically. So there really is an opportunity for choice by fintech firms. And that's basically what we're saying that you should think about before you talk to us, because that's really a key part of any business plan.
Thank you very much.
Thanks.
Hi. In your remarks in the other room, you mentioned that financial inclusion is the responsibility of all federally chartered institutions. I wonder how you could operationalize that within the test of whether or not to grant a federal charter to potentially a fintech company?
Sure. One thing I want to point out is when we talk about fair access and fair treatment, those phrases are grounded in the first section of the National Bank Act. That's really our mission. So in order to be a national bank, you really need to satisfy that aspirational requirement. What we are looking at is in terms of our supplementing our existing licensing manual to lay out for fintech firms in more specificity what we would be looking for in an application, and specifically in a business plan, which is really the key document that we assess as part of the application process. So there will be some guidance on what the expectations are. Again, I think there's a recognition that a fintech firm is different than a traditional brick and mortar based bank, so that this will be a very individualized process. And that's really what goes on when any group of promoters establishes even a community or traditional bank. You have to lay out what your business plan is and how you would meet those types of requirements.
Can you describe how the OCC works with FinCEN and what role you see anti-money laundering, other compliance, anti-fraud is playing in the fintech space with more banks coming into play?
Yes. Yeah, I'm happy to do that.
Sure. Two-part question.
Sure.
First, can you describe how you interact with FinCEN, the OCC FinCEN relationship? And then the next part is what level of risk do you see posed by money laundering, fraud, and other financial crime in the fintech space with OCC creating more national banks there?
Okay. First off, the Bank Secrecy Act has been around since the 1970s. The banking agencies, including the OCC, have been basically enforcing that provision or examining for compliance with it in our nationally chartered institutions, which include federal thrifts. So we have extensive experience. That is one of the laws that would apply to a limited purpose national bank. We have extensive materials that outline how examiners assess compliance under the BSA AML. This is also one of the topics that we see our Office of Innovation explaining to fintech firms informally. How does this law apply? Gives you some basic direction as to what you would need to have in place depending on the activity that you're engaged in. But the BSA, Bank Secrecy Act, and anti-money laundering laws apply to all nationally chartered banks and a variety of other financial intermediaries as well.
So I have a question around diversification of risk. So I know that in the proposal, it's emphasized that these fintech entities will be held to the same standards as other banks. Well, they'll have a much more limited product line potentially. And so how would you see a fintech company that has a very limited product line satisfy OCC expectations for diversification of risk?
A lot of this is going to be driven by your business plan, and what I want to emphasize is that this is really the supervisory expectations are tailored to what risk is embedded in your business plan. So that's the starting point. In terms of what we're looking for is really what types of appropriate risk management structures do you have in place given the risks in your business. So if you're a marketplace lender extending consumer credit, we're basically probably would be focusing in on your funding sources, which particularly if they're volatile. So we'd be looking for some type of compensating or buffers or protections involved there. That's the same reason why we, in terms of our supervisory expectations, we'll be looking at the capital and liquidity of a particular firm as well. So we do have some basic requirements in the area of capital and liquidity. They're really probably not going to be germane or fit neatly with a firm that has very little assets on its balance sheet. So we're going to be looking at it on an individualized basis, but with the same expectation that this is a ongoing business, that you have thought out the risks inherent in your business plan, that you have in place structures that limit that risk, and then ultimately, that's the reason why we also looked at updating the receivership provisions in the National Bank Act so that if an institution does fail, it'll be a soft landing in terms of your customers. But again, we'll be looking to make sure that there is not undue harm as a result of a flame out of one of those firms.
Thank you very much.
The new president campaigned for deregulation. There's been a lot of speculation about what changes we might see from the OCC in response to the executive orders that were issued recently. I wonder if you could share with us whether there have been any communications from the White House or otherwise concerning things that they would like to see you doing, and perhaps you could tell us what, if anything, you anticipate happening in response to the change in administration.
Sure. First off, I think there's, throughout my career, and there's a tradition at the OCC to actually look at being as most effective and efficient as we can be. We just completed I don't want to sound bureaucratic, but a process, the GRIPR process. It's the really a decennial review of rules and regulations to determine whether or not there's unnecessary regulatory burden without a compensating benefit. We've done that. I think Congress will be devoting more attention to how we go about our rulemaking, making sure that we are appropriately assessing the benefits and costs of any particular rulemaking. One technical matter, I think in principle and in terms of how we operate, we look at being efficient and reducing regulatory burden, but the OCC is an independent agency, so we're not specifically covered by many of those executive orders. That's not to say that we're not interested in complying with the spirit of those provisions.
Comptroller, thank you for your service to the Commonwealth of Massachusetts and to the United States. So
Thanks.
it's been a long time, and we've appreciated all that you've done. As you can expect, one of the major drivers for the FinTech Charter is a desire for uniformity of regulation, dealing with the patchwork of state laws that come when you're attempting to comply on a state-by-state basis under the licensing structure and with the usury provisions. Now, the FinTech Charter would seem to give a certain amount of uniformity with respect to usury and fees that can be charged, which I think would be very helpful to the industry. But there's been litigation in the state of New York that raises a question about those receivables once the National Bank transfers those receivables to another party. And at least some question is raised as to whether that receivable can be enforced if it's above the state usury rate. As you know, many of the FinTech players do charge rates that in some states exceed the usury rate. Is it the expectation that the OCC, as part of its FinTech guidance, would attempt to resolve this confusion that's been created by the state of New York in the Second Circuit?
Okay, that's a multifaceted question. I hope my aging brain can remember every part of it.
It's about Madden.
Yeah, I know it is.
So, yeah.
Now, first off, I think in terms of uniform federal platform or framework is something that President Lincoln had in mind when he chartered the OCC in 1863. So that's been our purpose for 154 years, to provide that uniform, standard, consistent application of laws throughout the United States in terms of banking institutions. So, I think the idea of a special purpose national bank that FinTech firms could avail themselves of is wholly consistent with our history as well as the law. In terms of what the law is in terms of the exportation of interest rates by subsequent acquirers of a loan. I think ultimately the court's going to have to resolve that. But and I don't want to get on thin ice here, but from the OCC standpoint, this is what we conveyed to the Solicitor General. Our view is that the concept of valid when made is very important to the assignability of instruments. I think when you look at it from a regulatory standpoint, it's important that banks be able to sell a note of any kind according to its original terms if they need liquidity or for other balance sheet purposes. So ultimately, we're going to look to see what the courts come down with, and if it ends up with the Supreme Court or an act of Congress, I think we're going to need some clarity as to what the law is.
The decision, as you know, on remand was decided last week. If there's an appeal, do you think the OCC may choose to participate?
It's too early for us to comment on that. Thank you. Okay, you get another one then.
I wanted to know why your office would not be able to issue an interpretive opinion right now. I mean, the issue has been resolved at the Second Circuit level. It's really indefinite as to whether if and when the Supreme Court's going to get the issue again. And you've already stated your position in an amicus brief. Why not issue an interpretive opinion?
Well,
I think that would be very helpful.
No, the OCC has the comptroller has a lot of authorities, but I can't overrule a court.
Well said. Just as a footnote to your excellent question, an interpretive opinion is a, quote, regulation according to the President's executive order. So two interpretive provisions or regulations would have to be repealed if he were to do what you were suggesting.
Yeah, thank you, Con, for reminding me. I'd like Beth Knickerbocker to stand up. She's our acting Chief Innovation Officer at the OCC. She's made great progress. Great progress in setting up the office. She is a little bit overwhelmed, but she is available for questions and comments. And that's what I'd like to leave on that note. I really encourage everyone in this room, whether you're a bank affiliated or fintech firm affiliated, that's what our Office of Innovation is for. We at the OCC deliberately are getting away from communicating solely through supervisory means, and this is really a great way into the OCC informally, and to get an opportunity to tap into all the resources that we have in terms of the skills and expertise and experience. Thank you.
I want you to look around the room here and see how many people are standing in the back. If the fire marshal knew about this, we'd be in a lot of trouble. As long as we are running events like this, you are always welcome to appear. Just don't expect this kind of crowd every time. Thank you again.
Thank you.